coming up.
Without mandatory parental controls or algorithmic accountability in C-63, how do we ensure platforms are actually protecting children?
Great question.
The question I put to you, Ms. Panas, is do you think that law enforcement and judges should have more tools to provide no contact orders for criminal harassment online? Do you think that's a good idea?
Look, to even get
This Guy's Garage. Like and subscribe.
And I want to start with you, Ms. Selby, if I can, because, we have the Canadian Constitution Foundation who has said on record that Bill C-63 combined things that have no reason to go together. Van Geyn said the issue of the online sexual exploitation of children through pornography is urgent and serious and should not be lumped in together with the government's controversial plans to criminalize all kinds of speech and allow for civil remedies through the Canadian Human Rights Commission for Speech. My question to you is, shouldn't we have a standalone bill or legislation that protects children from online perverts? Shouldn't that be its own legislation?
Mrs. Selby, you're on mute.
Sorry. We definitely need regulation to protect children from sexual exploitation online. I wouldn't use the term from online perverts. I think there are many groomers. There are many reasons why children are exploited on the internet, and there's obviously a market for it, or it wouldn't be such a problem.
I guess I'd push back, and I would certainly call those groomers perverts. So I guess we just have a difference of language. But I see your point. But I think what I'm trying to ask you is, shouldn't we have a standalone policy that enforces laws to protect these children and also ensures that social media platforms have a duty of care to ensure they're not allowing this to happen?
So this is where we have a glitch. I believe that all internet platforms have a duty of care, but we need regulation that is what I would call best in practice to protect all children and vulnerable individuals on the internet. So under the age assurance umbrella, you have numerous tools, and if they are legislated to happen at the device level, everyone gets protected. Picking and choosing just certain media sites is not the only answer here. Very few people are protected when you take that approach. You need a broader approach to all internet providers, all internet platforms.
And I think we would agree on that for sure. I guess what I'm trying to say is there's a bill that the Conservatives have. It's called 412. It was put forward by my Conservative colleague, and it deals with exactly what you're saying immediately, as opposed to C-63, which the Liberals have combined two separate issues that are not targeting the predators online and the sexual exploitation to I can't remember your last name, I'm sorry, Ms. Hoggin's point of these young children whose brains are forever changed. There's not a parent out there that isn't concerned about this. But I think the issue, go ahead, yeah.
I view it as child sexual abuse via digital images. And there isn't a child protection expert on the planet that would agree it is okay for children to have this kind of exposure. 100%. And I think that's where we're going with this, whereas C-412 directly deals with this immediately, as opposed to C-63, which has combined too many issues that will not hold these perpetrators, or I will call them perverts, to account, as well as social media platforms, to your point, that exactly need to have accountability. If I can turn to Ms. Hoggin, I was very interested in your testimony. It was profound, and you hit a lot of nails on the head in terms of the impact that this is having, social media is having on our children, and exposing them too young to this. Without mandatory parental controls or algorithmic accountability in C-63, how do we ensure platforms are actually protecting children?
Great question. So having a positive duty of care, I think, is a really critical component of the Canadian bill, because it says you have to be actively thinking about how your product might be misused and designing proactively for it. So parental controls, I think, can be really powerful. They are a set of tools, but not all children have parents that understand technology well enough. Remember, most parents today didn't grow up as a 10-year-old with a smartphone, right? I hope not. And it means that we need to make sure there is, at a minimum, a floor, a net that is catching all children. Because we also need to ask, should we be putting the obligation on parents when they have so much already that they have to deal with, to also stay abreast of exactly what threat is coming from where and what setting and toggle do they need to put on their phones.
Mm-hmm. So are you familiar with C-412 that my Conservative colleague put forward?
I don't know all the details for it.
I would love to. I'd love to direct it to you or send it to you. I think it's addressing what you're saying and getting to the heart of the issue quickly and more efficiently than C-63. Another question for you is, how does C-63 ensure platforms understand their obligations without explicit definitions?
Great question. So one of the challenges when writing any kind of internet regulation law is that technology moves very, very quickly. For example, right now the Europeans are putting in provisions around or suggesting things like banning addictive features. In technology, it can be really hard to define what is an addictive feature. Like if I say, this is the thing you're not allowed to do, what usually happens is either the definition is specific enough that's easy to understand, in which case the tech companies immediately just do a slight twist and say, well, it's not it anymore. Or you have a situation where you write them at such a high level where what does it mean to have an addictive feature? So duty of care is a nice kind of flexible in between where you say, hey, you need to be demonstrating proactively that you are looking after the needs of children and designing safety by design.
Thank you very much.
Can I please ask you if you think that having freedom of expression includes this kind of hatred that you have faced? Please, if you can elaborate a little bit.
And thank you so much for the question. And I would argue, I have so many privileges that I actually, do okay. This is with all my privileges. I can't imagine children and youth and people who don't have the privileges, like the support of my employer and the people around me. So, and that's with all those supports. There is freedom of expression, but there's consequence. We all have consequences for speaking. You folks in the House of Commons can't just say anything you can in the House of Commons with some consequence. That has to occur online, and it has to occur in all of our spaces. Because today, again, I do not have freedom of expression. Even just visibly posting a picture of my partner and I being happy at dancing at a concert comes at a cost. And that cost often is ridicule, and that cost turns into harassment, and then that cost turns into people believing the disinformation that is spread online, which leads to policies that restrict my ability to even participate fully in society. It goes so far, and this is somebody with all the privileges that I have.
We'll move to our second round, and we will go to Mr. Brock for 5 minutes, please.
Thank you, Chair, and I thank the witnesses for your attendance. And I echo the commentary of my colleague, Ms. Ferrari. This is such an important discussion that we're having today. And I just want to clarify, I heard you, Ms. Hogan, say that you are not familiar with C-412, which ostensibly achieves the same result in terms of keeping kids safe online. But we get to it versus C-63 in vastly different ways. So it's unfortunate that you haven't had a chance to review that. Can the same be said for you, Ms. Selby? You're not familiar with C-412?
I've only glanced at C-412 and haven't looked at all the in-depth recommendations.
Okay, thank you. And you, Ms. Panas, have you had a chance to look at C-412?
At a very high tertiary level, but not deeply, no.
Okay. I'm actually going to start with you, Ms. Panas, because I listened very carefully to your opening statement. You reiterated that in some of the questions that were put to you, that ultimately you feel safe in this environment, but the same cannot be said when you actually leave this building. You talked about various avenues of online harassment, and let's face it, that's the reality that Canadians are facing. It's not necessarily just children, teenagers, but it's also adults. There is a legal definition of criminal harassment in the Criminal Code of Canada, but what's sadly lacking in the Criminal Code of Canada is provisions to deal with online harassment. And sadly, and I can say this because it's a direct indictment against the Liberal government, Bill C-63 contains no provisions at all that deal with online harassment. C-412 does, and I don't know if you had a chance to dive into C-412 to take a look at the provisions that deal with online harassment. But the question I put to you, Ms. Panas, is do you think that law enforcement and judges should have more tools to provide no contact orders for criminal harassment online? Do you think that's a good idea?
Look, to even get to a situation where I have the courts involved and police involved would require me, a person who is already unsafe online, a person who's already facing enormous costs just to being visible, to have to report, to have to be believed by the police in the first place that these things are happening, that to have to address all the biases that are inherently built in law enforcement against trans people, that I'm more likely to just do nothing and probably withdraw. That is the consequence. And so you can give them all the tools that they want, but that requires reporting, requires people to believe and have a safe process. Bill C-63 provides means for us to be able to do that in a way that I feel that I would be believed for the first time, and that I would be supported for the first time, that would find some avenue to get that far. By time it's gone to police... I'm
going to interrupt you there, but C-63 does not provide an avenue for you to deal with online criminal harassment. It is a glaring oversight. C-412 provides a ready, able mechanism that addresses some of the concerns that you deal with. I just wanted to highlight that to you and encourage you to review that. I'm going to move on now to Ms. Hogan. Ms. Hogan.
I'm sorry, I have to question you on that, because the best thing we can do is avoid these online harms from happening in the first place. By the time they get to the police and the courts, we're too late.
Thank you. Ms. Hogan, I heard your comments on AI avatars. Do you think it's important to have a broad definition of online operator with regard to the responsibilities tech company operators have and how their products interact with children in order to ensure that technological advancements don't outpace protections for children?
I think we've seen really strong approaches out of places like the UK, where they have standards like reasonably likely to encounter versus products that are designed for children. We need to think expansively around that access question and around what does it mean to be social, because any spaces where extensive communication takes place, where kids have ongoing relationships that are facilitated by technology, we want to make sure that they are future-proofed under a similar umbrella. Thank
you. I believe that's my time.
Yes, thank you very much.
If something is posted online that's offensive, it involves some of the things we're talking about, which I won't use examples, C-63 provides for a method to have it taken down from the internet right away. Contrast that with this so-called 412 solution, which would require somebody to go out and retain a lawyer, put together some sort of application or motion, go before a judge and try to convince him or her that this should be taken down. So first of all, you're dealing with people who are the most vulnerable, who don't know how to find a lawyer, who can't afford a lawyer, and you're going to have to find a lawyer who knows how to deal with this and appear before a judge who has no expertise in this. It's an insulting joke dressed up as policy. It's not effective. So I'd like to get that off the table. And I'm assuming you agree with that, Ms. Panas, because you've already highlighted the importance of having the ability to deal with this quickly.
Oh, I couldn't agree further, or couldn't agree more. I would challenge your conservative colleagues if you think putting yourself in front of a Christmas tree is giving you some grief online. I encourage your conservative colleagues to tweet support for trans people and trans rights and say trans women are women and see what kind of hate and abuse you get.
Right.
That's what I live with every day. You folks get to walk out of here, take off your MP hats and be okay. My identity, I don't get to take off my trans identity and be cis for the rest of the day because life is hard. My life is hard all day, every day. And that means trying to find a judge that will, or lawyers try to, again, find police that will even believe me that this thing even occurred. I would just, it's not possible.